Thank you, Thank you everyone for joining us. Welcome to Beyond the Will, How to Secure Your Legacy and Build Generational Wealth Through Estate Planning with Legacy Counselor Sakisha Morgan. This is part one of the series titled Estate Planning 101. It's not just for the wealthy. Thank you all for joining us. My name is Naomi Demsas. I am on the leadership team of the Eritrean Diaspora Network. We are excited to introduce Sakisha Morgan, our presenter. Before we do that, for those of you new to the Eritrean Diaspora Network, EDIN is a community organization dedicated to the advancement of the Eritrean diaspora through nonpartisan community programming. One of the ways that we do that is through professional development. EDIN has a professional development network, and the primary objective of this program is to promote the spirit of networking and cooperations among Eritreans in the diaspora and help foster their individual and collective success by providing networking opportunities, supporting the development of Eritreans in their given careers through various programming efforts. We are enhancing awareness of the professional accomplishments of Eritreans within the Eritrean diaspora. And we've also hosted over 22 workshops on various topics, including finance, immigration, grad school, breaking into tech, and now estate planning, along with the Eritrean American Bar Association. The Eritrean community always comes together when there's a loss or death in the community to raise funds and to support families. It's the hallmark of our community. However, it is also essential for us to understand proper estate planning to protect assets, to alleviate legal complications, and build generational wealth. This series aims to provide education about the basic tools of estate planning, such as wills, trusts, and power of attorney. The workshops are intended to introduce planning issues related to probate, guardianship, titling of assets, community property, and estate taxes. For this event, we are especially excited to be partnering with the Eritrean American Bar Association, and I will let Saron tell you a little bit about the Eritrean American Bar Association.
All right, greetings everyone, either good morning or good afternoon, wherever you're logging in from. My name is Saron. I'm an attorney with the Sacramento County District Attorney's Office in California. I'm also part of the Eritrean American Bar Association, and we're very proud to co-host today's event with the Eritrean Diaspora Network. The Eritrean Bar Association is an inclusive professional network of Eritrean American attorneys and law students all in the United States. We have a three-part mission. Number one, build a strong professional network to support fellow Eritrean American attorneys in their career. Number two, motivate and guide young Eritreans on pursuing a career in the legal field. And finally, number three, to empower the Eritrean community with knowledge of their legal rights in the United States, hence why we're co-hosting this particular workshop. If you are interested in joining the Eritrean American Bar Association, or either becoming a mentor or a mentee or attending future events, please reach out to us on our website. It's www.eritreanaba.org. Drop us a note in our contact form. We'll definitely get back to you. And yeah, so thank you again for having us.
Yay, thank you, Saron. A couple housekeeping items before we start. Please keep in mind the mission and values of both the organizations and respect this space. There will be an opportunity to ask questions, but please, so you can either add them to the little Q&A feature or the chat box, or at the end of the presentation, if you raise your hand, we could pop you over as from an attendee into a panelist, and you can ask your question live. If you take pictures or talk about how awesome this event is, please tag EDIN. I know that the Eritrean American Bar Association is also on LinkedIn, so tag them as well. Be sure to follow both the Eritrean American Association on LinkedIn and EDIN on all social media platforms at Every Diaspora. We will be recording this session. Don't tell your friends. And then have fun. We want you guys to enjoy this process and get your questions out. Go ahead, Sarah.
Thank you. And with that said, let's jump into our workshop. Sakisha, please take it away.
Wait. Hold on. We got to introduce Shakisha before we start. Hold on. We've got to put her respect on her name. Just let's do a little quick intro.
Let me go ahead and do a quick intro for Shakisha. Shakisha Morgan is an attorney. She's a learner, strategist, and connector. She has over a decade of legal experience. She's an educator at heart. She affectionately known as the legal counselor, and she is the principal attorney of the Morgan Firm, LLC. Since graduating from Stanford and Georgetown Law, Shakisha has devoted herself to increasing access to Black generational wealth through her work conducting community and corporate workshops. She's delivered guest lectures and keynotes and provided transformative advice to her clients. She is a published author on topics related to estate planning, multi-generational wealth building, Black wealth, and servant leadership. Shakisha is a philanthropist and enjoys serving as a mentor and a board member of the Young Black and Giving Back Institute. She is a proud daughter of Jamaican immigrants, and she's a ride or die sister, a devoted wife, and a loving mother of a triumphant toddler. Outside of her career that she adores, you can find Shakisha co-hosting the Mary and Martha podcast, where she encourages Black women to live impactful lives of faith. We will put her website on the chat as well, so you can all reach out to her and get more information. And she's available to help with estate planning if anyone needs that and wants to connect with her after the session.
Thank you so much. I'm excited to be here with you all. This has been a phenomenal turnout. And I see someone as a listener to the Mary and Martha podcast. That's awesome. It's always good to meet people like that. In this capacity, I'm going to be talking to you all about estate planning. We are going to be having a 3-part conversation. So if you have not registered for parts 2 and part 3, you don't want to miss it. So make sure that you get a chance to do that when those links are available. I want to start by really kind of bringing us into the room. Okay, so let me just encourage you all that if you have a lot of things going on your side of the internet and on your side of the country, wherever you are, as much as you are able to focus on what we're doing here, it will be helpful to you. For a lot of people, when we talk about estate planning, it's a new thing. New things can be intimidating, but I hope that there's something that you learned today that you hadn't learned before, something that you think about today that you hadn't thought about before. And so that's going to require a little bit of your attention. As a lawyer, I do have to have a disclaimer that my session with you all today is educational. And so that doesn't necessarily mean that you have hired me as an attorney, that I am your attorney. You know, you don't want to leave the session and go, so my attorney was talking to me about yada, yada, yada. You might get me in trouble. So today is just an educational session. If you want to talk more, I am happy to do that. But today I'm just here in my capacity to help everybody learn. So we're going to have a conversation. So if you have questions, pop them in the Q&A chat, pop them in the chat, whatever you want to do. And if it is super pertinent to what we're talking about right now, I'm Jamaican, I'm used to being interrupted. There's nothing wrong with that. That's how my family has conversations at the table. You can't have a conversation with 14 people without somebody jumping in the midst of somebody saying something. So don't be shy to do that. So let's talk about estate planning. I think the first thing I want to remind everyone or say to everyone, if you're not aware, is that estate planning is community in action. You know, a lot of times when people think about estate planning, they're making decisions on their own, they're thinking about things on their own. This is such a big thing, but actually estate planning brings us together. When we do it the right way, we are not just having a conversation with ourselves in the mirror. We are having a conversation with those who are a part of our community. And there is the broader community of people who look like us within the diaspora, but then there's also people in our personal, intimate community, which could be members of your family, which could be super close friends and loved ones. And when people, and also includes advisors. And so when people start to come to me and they come to people like me to do their estate planning, everybody comes to talk to me about death. And I'm just like, whoa, wait a minute, let's pump the brakes, because estate planning is actually not just about what happens after we die. There's so much more to estate planning. There's so much beauty in the process of estate planning. And actually, I want to start with one of my favorite quotes when I start to talk to people about estate planning, because many times when we have conversations about estate planning, they actually end up making a difference in the life that you're living now. And you might be like, well, how does having a conversation with a lawyer about what I presume to be all matters related to death, how does that actually have an impact on my life right now? Well, it's because conversations about death are actually disguised conversations about living. What do I mean by that? I mean that when we start to think about the type of legacy that we want to leave, when we start to think about, I want my kids to know that I worked hard and I left the money to do something. That means that during your life, you got to work hard and you got to leave something for the kids. If you want people to remember you as someone who was loving and responsible and caring and kind, that means that during your lifetime, you got to do the things that reflect that you're loving and responsible and caring and kind. If you want to be financially responsible, you got to be financially responsible during your lifetime. So when we are thinking about conversations with estate planning attorneys, conversations with financial planners, conversations with life insurance agents, and all those kind of things, those conversations are actually conversations about who we want to be, because those turn into conversations about who we want to be remembered as, right? So when you're thinking about, I just want you to pause for a second here. And when you're thinking about the way that you want people to remember you, what are some of the things that come to mind? Usually when I do these workshops, because it's a webinar, I'm going to give you all some of the things that people sometimes say to me. A lot of people will say to me that they want their family to remember them as faith-based. And you can put this in the chat if you want to, about some of the things that you want to be remembered by. Some people say, I want to be remembered as someone who was faithful. What does that mean? That means that during your lifetime, you're exercising choices that reflect your faith. For some people, they want to be remembered as a family person. They want to be remembered as a responsible business owner. That means that during your lifetime, you're making those choices in order to do that. So just for a second, I want you to think about the type of person that you want to be remembered as. Somebody put in the chat that they want to be remembered as someone who wanted to break cycles. That's amazing. That's amazing. What that means is, that means that during your lifetime, you got to be someone who's courageous, someone who is inquisitive, someone who is unapologetic about the choices that they're making, right? Because those are the type of characteristics of people who break cycles. So when someone is remembering you, they're saying that that person was strong, they were courageous, they were determined, they were resilient, because those are the characteristics of people who want to break cycles. So when you think about for yourself, who do I want to be remembered as? Who do I want to be? What values do I want to reflect? That then guides how you're going to live your life. Now, one word that does come up a lot when people are thinking about how they want to be remembered is, I want to be remembered as somebody who had a little bit of money. And you know what? I don't see anything wrong with that, because that is, I would like to be remembered as someone who had a little bit of money and I left it for my kids, and I left it for my community, and I use it in a way that was conscious. But let's talk about what that means. What does the big word about wealth mean, right? Because we're here to talk about how estate planning is not just for the wealthy. Well, then let's talk about what it means to have wealth. What does that mean? Traditionally, people understand wealth to mean any kind of financial asset that families pass down to their children and to their grandchildren. So it was just about money. Did you pass down a house? Did you pass down multiple dollars? Did you pass down a business? Yes, that's what people saw as wealthy. But I would like to challenge that notion. I hope that you can tell by now, I'm not the typical kind of lawyer, right? I want to challenge that notion about what it means to be wealthy. And I actually want to push us to really start thinking about a modern understanding of wealth. Absolutely. Wealth includes tangible things like money, like cash, like investments, like stocks and bonds, like retirement funds. It absolutely includes property, which could be property in one state or property in multiple states, or it could be residential properties or investment properties. It could mean a business or two or three. As a daughter of business owners and as a business owner myself, that absolutely falls into this understanding of wealth. But there are additional things that when we think about wealthy people, we are also thinking about these things. We're thinking about education, right? As a daughter of immigrants, I actually didn't have an option of whether or not I was going to college, which was fine because I wanted to go to college. But when we think about building wealth in our communities, education is a huge part of that. We can't leave education out of the conversation, right? We also think about financial literacy because my parents didn't do all that they did and sacrificed all that they did for me to come and just spend the money as if I am, as if there's a non-ending, super ending, supply of money. And so I just use no sense of discretion as it relates to what I'm doing with finances. So it means I need to understand how to budget. It means I may need to understand how to invest. It also includes values, right? Family values, family traditions. One of my favorite family traditions, which I carry on in my own family today, is that every Sunday, a big meal was made and everybody sat down at the table. There was no TV on, there were no phones out, although we didn't really have cell phones when I was a kid, but don't age me with that. But we didn't have the cell phones out. We didn't have any, we had no other distractions but to spend time talking to each other. Now, in my family, that meant very loudly, we're Jamaicans, very loudly talking to each other and sometimes talking over each other, but it was a very fun experience, right? And what that meant was when I got to law school, it was easy for me to debate with people because I had been pretty much doing it my whole life. It also means time. Wealth means time and freedom of choice. What if I want to start a business? What if I want to hire someone to help me manage my kids, manage my calendar, manage the cleaning of the house? Wealth can mean those things too. So when I am talking with clients about estate planning and what it means to build wealth, I want you to be thinking not just about money, property, and businesses, but also to be thinking about how can my resources help to give my children freedom of choice? How can my resources help to ensure that future generations are financially literate? How can my resources help to pay for an education that could be life-changing when I know that right now, students are carrying the largest amount of student loan debt ever in history? So when we think about wealth, I want us to push beyond the typical of what we know about money, property, and businesses, and really to be thinking about wealth that allows for life-changing decisions to be made for our families, okay? And when you're thinking about that, that sets you up to think about estate planning. What does estate planning have to do with all of those things? Well, I'm so glad you all asked. I'm going to tell you why estate planning is so important and why, when you think about these things, estate planning is important for every single person that is here today. Number one, estate planning gives us control. Now, the word control has gotten a bad rap, okay? People look at control. I like to think of Janet Jackson's iconic song, but some people like to think of control as a bad thing. You just want to control me. Actually, what I'm thinking about is I'm thinking about control of my choices, control of the choices that I'm making. How important is that? Well, just think about it. Imagine you are an adult working a job, you got kids, you're building retirement, you're paying your rent or your mortgage or your phone bill or your car bill, but you don't get to make any choices about what you do with your money. And you don't get to make any choices about what you do with your time. You're bringing back the control when you do estate planning, because there are certain choices that you might lose the right to make when you don't do proper estate planning. All right. Estate planning allows you to bring in community. Remember, I said it's all about community. This is a community sport. This is a team sport. Estate planning is not just about you. But when we think about our community and we think about who can I trust to do something for me, with me, to me, right? On behalf of me, those are questions that when you think about them and you think about them in an intentional way, estate planning helps you to facilitate those decisions. So if I trust someone to take me to the doctor, to be able to hear what the doctor's saying to me, and to be able to give me advice on how to implement the doctor's advice, I'm thinking about how I can do that through estate planning. If something happens to me and I need to make sure that my kids get taken care of, I can make that choice using my control and choose who in my community would be a part of that. Because if I don't make that choice and something happens to me, then someone who's not in my community could have control over that choice instead of me. And then finally, estate planning brings us clarity. One of the biggest things that happens when people fail to do estate planning is people get confused. And I don't know about you, but if you've ever dealt with somebody confused, they don't make the best choices, right? So if you think about, I taught a workshop this morning. So I moonlight as a law professor at the University of the District of Columbia. I love my job. And I was teaching a workshop this morning, and I actually had a student there this morning. She had no idea I was doing a estate planning presentation later to talk about clarity versus confusion, and had no idea that she would be perfect as an example. She showed up this morning, she was tired, and she did a problem, and I was trying to talk her through the problem, but she was so confused that she became paralyzed. She could not make a decision. She could not answer a simple question that I gave her because she was so confused. Now imagine what confusion does to someone in a workshop practicing multiple choice questions before they go into their law school finals versus someone who's confused and has control of your estate, which includes all your money, which includes your house, which can include your kids and what happens with them. The last thing we want is uncertain people exacting control over things that matter to us. So estate planning, we don't just do it because it creates legal documents that tell people what to do. We do estate planning because it allows us to exercise intentional control, specific members of our community, and certainty and clarity that allows people to make good decisions for us. So that's why we do estate planning, and that's why it's for everyone. Because I don't know anyone who likes to be out of control. I don't know anyone who likes to have people they don't like or don't want doing things for them. And I don't know anyone who likes to be confused. So if you don't like those three things, then estate planning is for you. So let's talk about what those tools are related to estate planning. When we think about the legal tools of wealth creation, I'm going to give you a bit of an overview, right? So the reason why I encourage you to come to the second and third workshop is because we're going to do a deeper dive into each of these tool categories. So we have tools during our lifetime, which enable us to protect our power to use. And then we have tools that come into play after death, which help us to secure our legacy, build generational wealth. And we have some tools that kind of fall into a both category. They fall into sort of the and category. And so what we're going to be doing in future workshops next Saturday and the Saturday after that is we're going to be doing a bit of a deeper dive into each of these kind of tools. So I encourage you to be there because it's really going to give you more clarity and understanding about how to bring in your community so that you can exert your control over the things that matter to you. All right, here we go. Tools during your lifetime. You have probably heard about a power of attorney, but you may not necessarily be sure about what that means and why it is so important. Well, power of attorney means during my lifetime, I am giving someone the ability to act on my behalf. It's really that simple. The type of power of attorney depends on the type of control I want to give, the type of access that I want to give to someone. There are two big types of powers of attorneys. One of them deals with your legal and financial affairs. What do we mean by that? I mean, you can sign a contract by yourself. You can open a bank account if you have the ability. You can sign up for retirement and designate retirement beneficiaries. You can sell things, you can buy things. Those all fall under financial and legal decision-making that at the age of 18, we all have. I'm gonna repeat that. We all have the power to do those things at the age of 18. We may not have the resources, but we have the legal authority to do those things at 18. And so if we need someone to do them for us, we have to have a power of attorney. There's a power of attorney. It's called a durable power of attorney. It deals with legal and financial affairs, and it can be as broad or as limited as you want it to be. Most states have what's called a statutory power of attorney, which means it was created by the state's bar association, and it allows for people to sign a power of attorney document that gives someone the legal authority to act on their behalf. But remember, I said there's two types. So there's another type of power of attorney that deals with medical decision-making. So this is powers of attorneys that deal with who talks on my behalf if I can't talk for myself when I'm at the hospital, who gets to decide what medicine I take, what procedures I take, what I do with my bodily organs, where I live if I need to have long-term care. So these are just a few examples, but here's what I want you to think about. In any given day, you make dozens, if not hundreds of choices. Let's just talk about a typical day. You wake up, you choose what clothes to wear. You choose what time to leave the house for work. You choose, if you're a parent, whether you get yourself ready first or you get the kids ready first. Hint, parenting tip, wake up earlier and get yourself ready first, because once the kids wake up, it's chaos. All right. You also get to choose, if you have put gas in your car, what route you're going to take to go to work. You choose to walk into the building because sometimes we don't feel like being at work, right? All right. You choose if you work for an employer who gives you remote work or in-person work. And I mean, we really haven't done anything yet, right? We make so many choices in a day, on a daily basis, that it's important that we think about those choices and protect our ability to make those choices. And that's what a power of attorney does. It really is about protecting your power to choose. And so in next Saturday's workshop, we're going to go much deeper dive into what they do, what happens if you don't have them, and that scary legal process that happens called guardianship, how you can create them, and what you can include in them. So they are a really, really powerful tool, but here's the key. They only last during your lifetime. That's it. Once you pass, powers of attorneys don't matter anymore. Okay? All right. Then we have tools after you pass. And many people are familiar with this because this is typically what most people come to me and tell me that they want. I want to come to you because I need to do a will. And I'm like, okay, great. But here's another kicker. A will is not enough. And that's why this workshop is called Beyond a Will, because everybody thinks about the will, but a will is actually not enough. And you'll understand more about what I mean in the third workshop, when we talk about wills, trusts, securing your legacy, building generational wealth. A will is not enough. And so you need to be here to discover why a will is not enough and what else you need.
Shakisha, can I ask a question? Sorry.
Yes.
Sorry. Well, there's actually a question in the chat. So in our community, and I'm sure it's probably similar in the Jamaican community as well, but it's really taboo to talk about these topics and to talk about the power of attorney and will. And do you have any thoughts about how to actually go about trying to have these conversations with family members, or even with yourself, like to try to get over that hurdle?
Yes. So that, and funny enough, yes, it absolutely is something that is difficult to talk about for those of us within the diaspora, for those of us who are foreign born or have parents who are foreign born, first generation, I'm first generation American. It absolutely is difficult to talk about, but you know why it tends to be difficult to talk about? Because all people want to talk about is death. And who wants to talk about just death? There are ways to talk about the things related to estate planning without going, well, if you die tomorrow, what am I supposed to do with your stuff, Mom? I mean, that really, I don't know about you all, but that doesn't really inspire me to have a really great conversation. So here are some tips that I want to give to you. Number one, the very first, the most powerful perspective to come from when you're talking about these things is a perspective of someone who has done it themselves. You know why? Because that means that you understand about the process, you understand how important it is, and you actually have language to talk about things without just talking about the big kicker, which is death. Because honestly, I've been talking for what, 10, 15 minutes, and this is the first time that I've actually talked about death. Right? Like there's so much to talk about when it relates to estate planning, but because people have such a limited understanding of it, they come from the perspective of panic and they only want to talk about death. And that is not a good building block for good conversation. So how can you change your perspective of this? One is to learn more, to learn that there's so much more to estate planning. Two, to change the conversation. It is not your job to make your parents do their estate plan. But it is absolutely important for you to understand your parents' decision-making process, to understand things that are important to them, to understand things that they're concerned about, and then give them the tools to be able to solve those concerns, right? So if you have a parent that you know has property in another country, instead of going, well, what's going to happen when you die? Say, hey, I know you bought this property in another country. Do you plan on retiring there? Do you want us to have it later on? Do you want us to inherit it? You don't have to say after you die. Do you want us to inherit the property? Is there something you want us to be doing with the property? And then as you're having that conversation, you can go, oh, okay, you know, this stuff is really important. I think we should talk to a lawyer to make sure this all gets done. That's different than, well, what am I supposed to do with the house that you have in Jamaica after you die? That's panic.
Yeah.
Then there's curiosity. I see you bought a house in Jamaica. I'm
Beautiful.
literally telling you all how I had the conversation with my parents. I found out they were building a house in Jamaica, and I had a conversation with them about what they intended to do with it. So right now, you know, it's an investment property, but they plan to retire and be in that property. And so I had conversations with them about it. And then I said, well, you know, we should do some stuff on the legal side to make sure that the things that you're concerned about, we can address. The things you want to do, we can make it happen. And that changes the conversation. So change the tone of the conversation. Pay attention to your perspective in the conversation. Lead with curiosity. And also think about the timing of having these conversations. If you only have these conversations when there is an emergency happening, that means that the goal of the conversation is always something negative. Estate planning actually allows us to build. So if your parent has a business, okay, mom and dad, again, I'm literally using my own example. My parents own a business. It is not a business that I am personally interested in running. And so I said to them, how long do you all plan on having this business? Is there something that you want any of us to be doing related to the business? Are you going to give the business to your brother? Are you going to give the business to one of us? Have you started talking to us about the business? None of those was, well, what do you want to do with the business after you die? You want me to run a laundromat? That's not helpful, but curiosity. And so I think that those sort of things, how we approach the conversation, what we know before we approach the conversation makes a big difference.
Thank you. And then somebody asked in the chat, can these legal tools help in controlling family assets in other countries like Eritrea, for example?
It depends on what it is. And so specifically in Eritrea, I can't answer that question immediately. But you know, if you come back, that's an answer I'll have for you in the third session. But here's what I would tell you, that different countries have different rules. So again, I'll use Jamaica as an example because that's my family in particular. So I looked at the rules. In Jamaica, trusts don't really have much of an effect because as a practical sort of matter, everyone does wills. So everything goes through the court system. It's just, you have to think about how to do it. So, you know, for my parents, we've got to think about, okay, for any assets that are in Jamaica, we make sure we address that in the will because it's going to be the will that they take to Jamaica and deal with and not the trust. Great question.
Thank you. I'll let you go on.
I think I saw someone talked about modeling legacy planning. So I'm just going to read this comment because it's so good. Modeling legacy planning by inviting my parents to support me in the process really changed their outlook. Yes. They asked me to then support them in getting their affairs in order. They also asked me to speak to, you know, their, I don't want to pronounce names wrong, but they also, do you want to pronounce that part?
It's called mahabar. It's like or mahabar, yeah. It's like they all get together and kind of form these little, I don't know, what do you, it's like a
group.
A group, yeah, there you go.
Yeah. And that is so confirming, right? Because that's exactly what I'm saying. If you're pulling people in on your process, then they get to see how you're experiencing it. And a lot of people's anxiety is alleviated by watching what you do. Right? Excellent. Thank you so much for making that comment. Alrighty, and I want to read this other comment. Someone else said, when couched in terms of addressing quality of life and how it truly is an act of love to help your kin know how to support you through their life cycle, it is more accessible. Absolutely. Absolutely. So the way that we approach these conversations makes a difference. So think about how you're approaching the conversation and adjust as needed, right? If it's coming from a sort of panicked, sort of, we need to get it together because you could die any day, sort of thing, you're really not going to get far with it. Thank you so much for those comments. All right, so we've got a will. The will is what most people think of when we talk about estate planning, and it is absolutely an essential tool of estate planning. 3 essential tools, everybody should have it once you turn 18. The 2 types of power of attorney and a will. Now, again, a will is not enough because I just told you, you also had to have 2 powers of attorneys. Everybody who's 18 should have these 3. If you don't have these 3, I hope you start making plans to get them, because these are the 3 essential tools that everybody should have, because it's not about how much money you have. It's about your power to make choices. All right. So the power of attorney for legal and financial affairs, power of attorney for medical affairs, and a will. All right. Now, there are additional things that we need to talk about when we talk about considerations related to estate planning. One is business owners. I mentioned that my parents are business owners. I'm a business owner. This makes a difference, because if you're a business owner and we talk about legacy, building generational wealth, thinking about whether we want our businesses to continue beyond us, then we need to have legal tools within the business atmosphere. So you're talking about, if you have an LLC type of business, you're talking about an operating agreement. If you're talking about a partnership or corporation, you're talking about a shareholders agreement. If you're talking about a partnership, it's a partnership agreement. If you're talking about a corporation, shareholders agreement, LLC, you're talking about an operating agreement. And all of these are just the document that runs the business, that talks about the management of the business. And what it does is it can address what happens if someone gets sick and someone needs to step in, similar to a power of attorney. What happens when someone passes? What happens to the business and the assets of the business? Similar to will or a trust.
So is that this, let's just say you own the business, and generally this happens a lot in our community, is that the business is owned by like a group of family members, maybe siblings or whatever. Like, would that be the same? So I guess you would have a power of attorney or something for your specific share in the business. Is that how that would work?
No, but that's an excellent question. So you got to think about what controls the business and then what controls things personally. Those are separate, right? If we're talking about my personal decision-making and those kind of things, that's what the power of attorneys are for. If we're talking about business decisions for the business, that's in the operating agreement. So for example, the operating agreement might say, Shakisha as the owner makes decisions. But if Shakisha cannot make decisions, her sister will make decisions, right?
Okay.
But my sister can have her own power of attorney that says, for my personal decisions, for my legal, financial, and medical personal decisions, this is my power of attorney. The business says, if business decisions need to be made, here's who are making those decisions, and they do it through management agreement, which is an operating agreement, shareholders agreement, partnership agreement.
That's great. And then there's a couple questions in the chat, Shakisha, so I'll just ask them. Somebody asked, can I give my legacy legally to someone living outside of the United States?
If you are using legally enforceable documents, you can give anything to anyone. Honestly, it's when, and in fact, actually, we have had situations where things are supposed to go to people who are outside of the United States. It just creates a bit of a logistical thing. So if you're writing, if you're actually preparing your own legal documents through an attorney, and especially if you're talking about foreign assets, I really would use an attorney to do that. But what I would say is don't just include what goes to whoever. Also think about how you send it to that person. So for example, I have a client who sends money to their mother. Again, now listen, once you tell people that you're Jamaican, all the Jamaicans come to you. So a lot of my examples are Jamaican, but it applies across the board.
Yes, it does.
So my client sends money monthly to his mother in Jamaica. And so I said to him, okay, so if there was someone else who needed to act on your behalf, would you want them to continue to send money to your mother monthly in Jamaica? He said, yes. And I said, now, how do you send the money? Because it's not just enough to say, hey, get the money to my mother. If you give someone no directions, no how to, now they know that they're supposed to give it, but they don't know how to get it there. And so now the money is delayed because they're going, well, is it Western Union? Or is it Zelle? Or is it Cash App? Or is it PayPal? Which one is it? Well, not PayPal. It's not really international like that, but you see what I'm saying? So we're not just thinking about the who, we're thinking about the how. And that's why it's important to have these conversations, because you want them to be layered. Excellent question.
Great. And then another question is, are there any tax implications to consider when using legal tools in estate planning in the US?
Yes, depending on the type of tool that you're using. So the next tool that I was going to talk about, now for the tools that I've talked about here, not really, unless you are someone who meets what we call the estate tax limit. So there are, generally speaking, three sort of big buckets of taxes in the United States. You've got income tax, which we all pay if we're working. You have got estate tax, which says that if my estate, if all of my stuff added up values over a certain amount, I have to pay a tax once I hit that amount. So for example, in the District of Columbia, I'll just use DC as an example, because every state doesn't actually have an estate tax. There's two, there's state and then there's federal. So some states have it. So DC has it and it's 4 million. So if you are worth more than 4 million, above the 4 million, you pay a tax on it. That's the estate tax. Federally, it's like 12 million, 12.9 million. And so if you're worth 12.9 million or more, everything above that 12.9, you pay a tax on it. That's the estate tax. Most people who are doing estate planning don't have to worry about the estate tax. I would love it if about 2 or 3 generations away, my kids would worry about the estate tax, but my current ones, you know, it's not a big deal for us right now. All right. Then you have inheritance tax. And inheritance tax really applies depending on the state's rules for inheritance taxes. But typically, if someone is a direct descendant of yours, you're not worrying about an inheritance tax. If your state has an inheritance tax, then it's usually for people who are not direct descendants. So nieces, nephews, friends, those kind of things. And so the percentage, there's a percentage on the value of what you're leaving them that has to be paid in inheritance tax. And you can decide if you'll pay it through your estate or if the person receiving the gift is the one who pays it. So those are generally the 3 taxes that we think about. If you're a business owner, there are some things that we need to think about. If you are someone who has investment properties, there are some tools that affect different types of taxes. So it's important that when it comes to the tax piece, you are talking to an estate planning attorney so that they know if the tools that are right for you have any sort of tax implications. But those are the big ones to be thinking about.
Thank you.
All right. So we have businesses, and I already mentioned this, but also trusts. Trusts are a wonderful tool, and you really should come back in the 3rd session to learn more about trusts, because honestly, they have so much good to them, but they're not for everyone. And you'd be surprised who I tell you they're for and who they are not for. And ding, 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 they're not just for the wealthy. If you are someone who has young children like me, you should really be thinking about using trust. If you are someone who owns property in multiple states or jurisdictions or in another country, you should be thinking about using trust, right? If you are thinking about, let me just answer this quickly. Inheritance taxes do not apply to spouses. Usually a spouse is exempt from any inheritance taxes. If you are someone who is leaving money for someone who is incarcerated or irresponsible, then typically you want to think about using trust. Trusts are so powerful because I want you to think of them as houses. There are so many different types of houses. There are so many different ways to use a house. There are so many different family structures within a house, right? So you could use a single family home versus a townhouse versus a duplex versus a sprawling estate out in the country. They all have different goals, right? When you think about, all right, I want to buy a house, you don't just jump onto Redfin or Zillow and start looking. You start thinking about what it is that you need. So you start thinking about how much space you need. Then you start thinking about, do I like the open plan, or do I prefer a house with lots of structures in between and walls? Do I want to have 2 floors or 3 floors or 4? Do I want to have a big backyard? Do I want to have a pool in the backyard? Do I want to be in a neighborhood that has lots of kids? Do I want to be in a retirement neighborhood? As tailored as you can make the process of buying a house is as tailored as you can make the process of creating a trust that works for you. Even if you bought the same type of house or use the same type of trust as someone else, let's say everybody in the neighborhood has a single family home. Each of those functions differently. There's a different amount of people living in the house. There's different layouts in the house. Some people are living in a residential house. Some people have tenants living in the house. There's all different sort of things. So trusts are a beautiful set of tools within estate planning that when you think about building generational wealth, that's what they're for. They really are for saying, I'm thinking about the fact that I have young kids and I want to make sure that they can go to college without paying for it. We're probably using a trust to do it. I'm thinking about the fact that I'm a caregiver for multiple people, some of whom are legally related to me and some of whom are not. You think about using a trust. And so if you are interested in learning more about trust and the multiple ways that we can use them, I really invite you to our third, because it's going to be all about securing legacy, building generational wealth. And we're going to really be doing a deep dive into how we use trust. But let me just give you some general sort of things. People use trust in conjunction with resources. So no, you don't need to be wealthy to have a trust. You don't need to be cash wealthy. But if you are someone who has a life insurance policy, it's a great way to use a trust. It's a great way to say, I have $1 million, I have $100,000 life insurance policy, and I really want to make sure that it's used well for the people I have left it for. You can combine that with a trust, and you can be really intentional about how it is used. All right.
I have a couple questions. Sorry,
Go
Shukisha.
ahead.
So first, just in terms of cost, right? Like I know that there's, I'm also a lawyer, so I know that there's 2 ways that you can go with, estate planning issues. There's probate, and then there's also planning, right? Just in terms of cost, can you talk a little bit about the cost of each of those processes?
Yes, absolutely. Let me start by reminding everyone about this phrase I'm sure everyone has heard about, and it's called opportunity cost. An opportunity cost says, I have the opportunity to do something, and when I choose not to do it, what is it going to cost me? That's the choice that you're making when you do probate versus planning. I really love that phrasing, by the way. If you see me use it in a future sort of thing, we'll give you attribution, but that is genius. All right. When we think about probate collectively.
And sorry, some people might not know what probate is. So
yes.
You want to go into that? Yeah.
Yeah. Probate is the legal process where people have to go to court to get legal authority to take control of your estate pay your debts, and from the balance of what's left, if any is left, they will then use that to either distribute it to the people that you have listed in your will, or if you don't have a will, they will distribute it to the people that the court tells them to distribute it to. So if you have $50,000 as a part of your estate and you have debts worth $45,000, then the $5,000 is what would typically be left to give to your descendants. But you have legal fees, you have fees to open probate cases, means to go to court, you have to pay. I know that's crazy, but it is, it's a part of it. You have to pay publication fees, which means that when someone passes and it goes through the court process, you have to publicize that someone has died. And depending on the state that you're in, that can be anywhere from $50 to $500, depending on what the rules are. And I do really mean that. In the state of Maryland, it can cost you $400 something. In DC, it can cost you $40. And they're right next to each other. So it's just because they have different rules. And so after it's publicized, then you have to wait for people to file claims. So people who say you owe them money, they're going to file claims first, and they get the first bite at the apple. So if that totals to $45,000, you got $5,000 left, you're paying off court fees, and then what's left from that goes to whoever the court says, or if you have a will, whatever the will says. It's a wonderfully terrible process, okay? And I'm telling you this as someone who gets paid to do the process. It is a terrible process for families. Even the simplest of processes makes it terrible, because I tell people to expect that you'll be doing it for a year to a year and a half after you start the filing. So not after someone's died, but after you get to court to file. And you can't even get to court to file before you get a death certificate. And you can't even get a death certificate before you bury someone. So it is a long process. And so the last thing that you want people who you love to be dealing with is the court. I mean, people don't even like to go to court for traffic tickets. Why do you think people would want to go to court to deal with the confusing process called probate with all these rules? And I can't do anything for 6 months, and I can't, but they've got kids that need money for such and such. Well, the rules are such that if you did not take the opportunity to do estate planning, then you are dealing with the cost of probate. Now, what that could look like depends on a number of factors. That's the thing, is that the opportunity cost, you really don't know what it is. Because if you need to hire an attorney because they don't understand what's happening, that has a cost. If people decide they're going to do it themselves and they don't do it right because they don't have an attorney, the opportunity cost is time. So it could be 2, 3, 4, 5. I had a client who brought me in after 8 years of going through probate because the family was fighting and they finally decided to sue him. He thought he was doing everything right. And it was 8 years later. And I came in and I was like, oh, actually, you are doing things right. But here's what you could have done 8 years ago and you would have been done. So yeah, you could hire an attorney, that costs money. And so you get through efficiently, or you don't hire an attorney and that costs time. And then you end up hiring an attorney, which costs money, right? And so there are people who, I've had a client who spent just in legal fees because the mom owned a house in DC, she owned a house in Florida, and she owned a house, I think it was one of the islands in the Caribbean. Listen, Caribbean people find me, once Caribbean people know each other, is it? But just in legal fees, it was about 12 grand.
Wow.
Just in legal fees. And every state, DC, Florida, and the Caribbean had additional fees. That was just a part of the process. So this was just paying lawyers, right? And so the opportunity cost can skyrocket. Now, if you're talking about doing estate planning, the good thing about it is that costs are set, because most of the estate planners, I actually don't know an estate planner personally who I would recommend to people who doesn't charge flat fees, which means once you know what you need, they're going to tell you how much it costs. And once you know how much it costs, a lot of them will do payment plans. I mean, it's not to hire a private attorney, but a lot of them will do payment plans. And then a lot of them will say, I mean, if you come back to me before I raise my prices, the price is still the price. So you can save up for it. But that's the thing about planning. Just like if I know I want to buy a house, I need to have this much in the down payment, I plan for it. And I save up because it's that important. It's the same. So when we talk about estate planning, now let me give you some numbers. It depends on where you live, which really affects how much this costs. I would say more southern states are cheaper. So if you're talking about the Carolinas, the Floridas, that kind of stuff, they tend to be a bit cheaper. So if you're talking about, you know, $1,000 to $3,000, and that could include creating a trust. You go to the West, you're getting more expensive because states like California, their probate, my goodness, it's insane. It's actually insane. And so I send people to my California girl because I mean, what happens in California is ridiculous. I just have to tell you. So it is more expensive out West. Middle of the road is going to be areas like the DMV.
Okay.
So I would say that in the DMV, if you're paying for an attorney who knows what they're doing, it's probably not less than $2,000. But if you are like a middle class, I got a house, I got life insurance, I want to do a trust type of thing, it's probably not going to cost you more than $885, like, you know, but like I said, people will be, but that depends on, is it one person? Is it a couple? Is it a family? Is it a, you know, so that's going to give you the range. Maybe it's like 2 to 10. Like if you're a business owner, it might be a little bit more because you have extra stuff. But that's where I would say, and that is for people who know what they're doing. If you're choosing a private attorney and you're paying less than $1,500 for your estate planning, I would be nervous. I'm just going to tell you right now, because they're probably using form documents and it's not at all tailored to you and your family, or they're not explaining it to you, which if you have a lawyer prepare documents for you, they should explain it to you. So there's something that you're losing in the process.
I agree. We have a couple questions in the chat, so I'll ask them away. So Fevin asked, does a trust help shield assets of a business owner from litigation?
It depends on the type of trust.
So what type of trust would do that?
So there are 2 big categories for trust. You have revocable trusts, which allow for a lot more flexibility, and most people are going to get a revocable trust because the flexibility means that you can change your mind about stuff over time, and people want the ability to change their mind. An irrevocable trust, there are many types of it, but one of the types of an irrevocable trust is an asset protection trust. You have to be careful with those because you have to give up something to get something. So if you want to get protection, you have to give up control. So it is really important that you're talking with an estate planning attorney. What is it you're trying to do? Is there another way to get there? Because I'm not saying that I haven't done a revocable trust, but they have been for very specific reasons, and it had to be needed because you are giving up control in order to do something like that. So yes, they are out there. They're very specific. You shouldn't do it without an attorney.
Got it. And when you say legally related, are you referring to adopting a legal heir?
No, that's a great question. Legally, it's someone you adopt is considered the same as someone that was born of you. That's a legal adoption. But sometimes, and I am one of those, sometimes you bring people into your family and there are no legal papers. They just live with you and you take care of them. Okay. Those people are not legally related to you. So if you want to include them in your estate planning, you got to be specific in your estate planning documents. You got to give them that status because they don't have it otherwise.
Got it. How about if probate fees are over the amount of wealth left for distribution?
Excellent question. Your estate becomes what we call intestate, which means it's essentially your estate is bankrupt, but all of it is going to be used to pay as much of the creditors as possible. And then they declare it intestate. And if more money comes in, they open it back to continue paying the creditors.
Okay. And can you choose which state you to have a trust or probate filed?
Trust, you do not file a trust. Let me start there. You don't file a trust. A trust is a private document. It's kept out of the public purview. Anything that goes through court is public. Trusts do not go through court, they are private. And typically you will do a trust in the state in which you live. There are some exceptions to that, but you really need to talk to an estate planning attorney to see if you qualify for one of those exceptions. But typically speaking, your trust is in your state of residence. Probate, no, you do not have a choice. Probate is first filed in the state in which you live at the time that you die. So wherever you are a resident at the time you die, that's the first probate. If you then own property in other states, another probate, it's called an ancillary probate, another court case then has to be filed in every jurisdiction in which you own property, unless you have a trust.
Got it.
And all of those properties are in your trust.
Thank you.
All right.
Great.
But I do want to use that. I want to use that to segue. I see that question, but I want to use this to segue to talk about property real quick.
Okay. Got it.
Okay. I don't want to miss this point about property, because a lot of people, when they're thinking about estate planning and they're thinking about what to do, sometimes people take shortcuts, and people take a lot of shortcuts as it relates to property. And I just want to tell you all not to take shortcuts, because they do more damage than they do good. What's a shortcut that people do with property? They will just put their kids' names on their deeds, or you will let your parents put your name on their deed. Do not do that. Please do not do that. Somebody asked about taxes earlier. Here comes a tax, and it's called the capital gains tax. And it's not a friendly tax. It's an unkind tax. It's not ever going to be the tax that you invite to your bachelorette or bachelor party. You will not invite this tax to the cookout, to dinner, to brunch. Matter of fact, you see this tax coming down the road, you're going to lock the front door. You're going to close all the blinds. You're going to tell everybody you're not home and to stay quiet until the tax gets off of your front porch. Okay. This is not a kind tax. What does this tax do? It says that if someone sells a property, there is a basis for which the government calculates the gain from the sale of purchase, the price of purchase to the price of sale. This price of purchase basis changes depending on what you do when you put someone's name on your deed. Now, if your parents go, listen, we don't want you to deal with the court. We're just going to put your name on our property so that you have it because we want you to have it. You go, no, go see an attorney. Why? Because if they do that, let's say your parents purchased the property for $1. Wow, what a deal. And then when you inherit it, it's worth $20. Oh my gosh, what gains? And then the market goes crazy and you sell the house during your lifetime for $40 because you don't need it. So you go, I'm going to use the money from the sale to do something else that I know my parents want me to do to continue their legacy. So remember, house was purchased at $1. When your parent passed, it was worth $20. And when you sold it, it was worth $40. If your parents put your name on the deed while they were still alive, that purchase price to sale price, that gain is $1 to $40. That means you're going to pay taxes on a $39 gain. Now, obviously we know that it's not $39 that's going to be gain. It's going to be tens of thousands of dollars, and depending on where you live, hundreds of thousands of dollars. But you're going to have to pay a tax on it. Shakisha, how do I reduce the tax? I'm so glad you asked. You're going to tell them, if you want me to have the house, you can create a deed, but you put my name on it such that I don't inherit the house. I don't become an owner until after you die, which means now I have inherited the house at the date of death value, and that becomes my purchase price. Remember, when they died, $20. So now you sell it for $40. So now your gain is $20 instead of $39. So you're only paying the tax on the, you're still going to pay the tax. Don't try to get around the tax. Don't come to me asking how to get around the tax. I'm not doing that. Okay. I like my license and I like my practice. Don't ask me to do that. But how do we reduce the capital gains tax? We are careful never to trim. Let me not say never. There's always an exception to the rule. But generally speaking, for almost everyone on this thing, do not inherit property until after the person has passed. There are ways to do that. because you don't want to be stuck with the bill. All of a sudden, all this gain you now got all these taxes to pay for it. Okay. When we talk about wealth creation, it necessarily talks about wealth preservation. We can't preserve what we're giving away to the government in taxes. Hello. All right. I just wanted to say that because we were talking about property and I had to do my little property speech because I never talk about estate planning without talking about capital gains taxes. Now, what was the question?
Sure. So Nititi had a question. Is it possible to use a trust to protect your parents' assets and prevent them from being denied public benefits, i.e. state or federally funded healthcare?
Yes. And that's why you should come to the third session and I'll tell you how. But yes.
Thank you. That's a great answer.
That was a good quote, wasn't it? We can't preserve
Yeah.
what we're giving away to the government in taxes. It's the first time I've said that, but I hope it hit because it's true. All right. So yes, I am. You see, I'm promoting the second and third because there's so much that we can get into, y'all. And so I hope that you come back so you can learn more. All right. Let me just give you some important considerations for legacy. Some things that can be addressed in estate planning documents, but need to be thought about as a community. Where will I live and who will I live with? As I get older, do I plan to move? Do I plan to retire in a particular place? Some states have elective share laws. You don't even know what that means. I'll tell you about that in the third session. Some states don't have elective share laws. If you move from a state that doesn't have one to one that does has one, that has implications on choices you might make related to estate planning. What don't I know and how do I bridge my gap of knowledge? What don't I know about trust? How do I bridge my gap of knowledge? I come to the third session. What don't I know about powers of attorneys? You know what? I don't know what I don't know. So I guess I should come to the second session to find out more. What advisors will help me make the best decisions? Well, we are going to be talking about securing your legacy, building generational wealth. An estate planning attorney is not actually the only advisor that you need. And so depending on what you have and what you want to do, there are other advisors that will help you make good decisions, but also not just professional advisors, but also who do I trust within my circle of support, my family or close friends, loved ones, who can help me make good decisions, right? If I'm married, hopefully your spouse is listed in that group of advisors, because if you are married and have children, you all should be having conversations about choices you want to make that's going to impact your family for generations to come. When do I need to start making plans and when do I need to put the plan into action? Great question. You need to start making plans today, and you can actually do things today to start putting your plan into action. And I'll remind you of what I said earlier, that is something that you can do today. How will I use my resources? We talked about opportunity costs. We talked about cost of probate. We talked about cost of planning. Actually, I like to say cost of probate and investment for planning, because am I going to use my resources to invest in a better future for myself and my family? Or am I not going to use my resources, which then will be used to pay for the costs of not planning? Right? The best gift that you can give to your loved ones is a well-planned estate. That means I want you to really start thinking about all of the wonderful possibilities of things that can happen for you and things that can happen for your family, and start to do the things that get you there. So I'm excited to continue this conversation with you all. And if you have more questions, I'm excited to answer them.
I do have a couple more questions, and I think we'll wait for a couple just to see if other people have any in the chat. Have you ever seen conflicts among family members of a deceased person that could have been avoided? And if you could share an example or a story, that would be great.
I think the hardest thing that you just asked me is to share a story.
Yeah.
Because there are so many. But one in particular comes to mind when I think about a family that had a property in DC, and they were a blended family, which meant that the mother brought children to the marriage and the father brought children to the marriage. The situation in the District of Columbia is if you do not have a will or a trust or anything that addresses what happens after you pass, then your jurisdiction, and this happens everywhere, your jurisdiction has rules about what happens. So they bought a house together, and because they didn't have a will or trust, the deed said that the husband and wife were the owners. And that meant that whichever one of them died first, the survivor then became full owner of the property. But they were a blended family, and they raised the entire blended family in this house. But they never adopted each other's kids, which meant that under the law, the stepchildren had no legal status and thus no legal right when the survivor died. So in this particular instance, the mother died first, which meant that after the father died, only the father's children got to inherit the value from the cost of the sale of the house. Because the family didn't understand that. According to them, like their mother had owned half of the house. So they should have gotten half of it. This is what I talk about when I talk about uncertainty. Most people are not well versed in the law. So you're going to make an assumption about what's going to happen. So you're not going to do things. And then you get hurt when you find out that things go differently. And so we were actually in court where the mother's children were filing claims against the estate, saying that they should be allowed to have some of it. And when I tell you that the judge was sitting there and said, I wish I could give you a portion of this house, but by law, I am prevented from doing so, because under the law, you are not the father's children. And thus, you cannot inherit from him unless he had done a will. Now, what did that mean? Because all of the children weren't really aware of what that meant and what the law was, by the time they got to the hearing, there had been so much dirt slung back and forth, so much so that one of the father's children stood up in court and said, Your Honor, they don't even deserve to have none of the house. Their mother didn't even like them that much. And I'm just like, first of all, everyone in here is 50 plus. So all of the drama from the 50 plus years of them growing up together all came down to the court. But the judge said, I hear you and I wish I could do it for you. But by what the law says, you're not entitled to any of this. The only way you'd be entitled is if your stepbrothers and sisters gave you a portion, which meant that it gave an opportunity for those who were selfish to say, well, the law allows me to take it, so why would I give you any? It's broken families.
That's really heartbreaking.
It is heartbreaking, and it is not uncommon. I can
Yeah.
tell you 5 or 6 more stories just like that.
Okay.
Easily. And so if there was just a little bit of planning that the mother and father, now I also recognize that in our community, we have access to less information. And so that's why these sort of events are so important, because it's sharing the information that we just didn't know before. But if they had just done a little planning, it would have gone a long way.
Yeah. Finot has a question, which is, what are some immediate low-hanging fruit people can do to get started now?
Excellent. Remember, I said a will is not enough. So if you have any retirement accounts, if you have any life insurance, go back and check your beneficiary designations. You can make beneficiary designations right now that if they are beneficiary designations, they are not controlled by a will. So someone would not have to go to court to get them, right? If they are retirement or life insurance or whatever that don't have beneficiary designations, you're going to be requiring people to go to court to get access to them. And I tell people to check them because I have stories for days, but I'll tell you the story of a guy who came down and sat down with me, and we were going over his stuff, and he had been divorced about 15 years, but his ex-wife was still on his life insurance because he never went back and checked it. And I said, sir, if you don't change that today, you die tomorrow. Relationship you told me you had with your ex-wife, are you sure you want her to have all this money? Tell you another story. Somebody else didn't change their beneficiary designation and then they died, but they were married to someone else. They had a new marriage with kids. And then the current wife, the surviving wife, sued the ex-wife because she shouldn't have gotten it. but by law, he hadn't changed his beneficiary designations. She was by law entitled to receive it. She ended up throwing her a couple of dollars, but she actually was not entitled to by law. She just didn't feel like going through a court case.
Wow.
And that was the only reason that she got any money, but she actually didn't get as much as she could have had people just gone and check their beneficiary designations to see that they made sense. Number two, when you check your beneficiary designations, do not put someone who is under 18 as a beneficiary designee. And I'll tell you more about why that is important in our third session.
Got it. Robel asked, can you please clarify again the difference between estate and inheritance tax?
Estate taxes is what the federal government or your state imposes depending upon the value of your stuff at the time you die. Inheritance taxes is solely a state thing, and it is what is imposed if you leave something from your estate to someone who doesn't fall under an exempt category, like a spouse or a direct descendant.
Thank you. And Lily asked, are there any lawyers, legacy counselors you'd recommend to follow who share tips in the Canadian context?
I haven't seen Canada so far, but let me try and see if I can find someone before we finish these sessions.
Thank you. And Fevin asked, what's the difference between inheriting property via a deed versus a will?
Inheriting property via deed is similar to a beneficiary designation, which means you don't need to go to court. If you inherit something through a will is enforced through the court process. So you have to go through court to inherit from a will.
And then Winta asked, investment accounts, e.g. 401ks, count as beneficiary designations and do not need a will, right? I guess
Everyone needs a will. So let's start there. Everyone needs a will. And if you have investment accounts like 401k, like 403b, like TSP, et cetera, and you have adult beneficiaries who you want to inherit from those accounts without going to court, you should name them as beneficiary designees. And then, no, it won't be controlled by the will. It'll be controlled by the beneficiary designation, but everybody should have a will. Remember, I said a will is not enough, but it is an essential tool. So we are will and beneficiary designations.
Thank you. Kimberly asked, if you are single with no children, how do you choose life insurance and beneficiaries?
Oh my gosh, I love working with people who are single with no children. You guys are the people that keep the good things in the world going, honestly and truly. Because a lot of times people who are married or who have kids or both, just leave it to their kids. But how much, I mean, I don't want to get too political here, but the government cannot solve all of the issues that are going on. Community organizations, houses of worship, people who deal with orphanages. I mean, these are people who are funded by the community. And so you have an excellent opportunity to really put your money towards things that make the world a better place.
Thank you. And Rakia, I hope I didn't say her name wrong, but Rakia, if someone had a question, if someone is legally married but separated and owns a house, can they add a child to their deed to receive the house when they die, or will it automatically go to their spouse?
That is a more complex question. That deals with the phrase that I came up with. I didn't come up with it. The phrase that I mentioned earlier, the elective share. That's really going to be something that I can talk more deeply about in this third session. Here's what I would say. It depends on the rules of your state, because elective share very quickly really talks about if you don't leave anything in your estate to your spouse can elect to still get a certain portion if their state allows them to. So there's not actually an easy answer to that question, because we would have to be looking at what else was in your estate. And if you are in a state with an elective share, and what other tools you could use to leave stuff for your children. So the one thing I would say to you is you need a lawyer to do your estate planning, and you should come to the third session.
And I think you already answered this, but can one designate people in foreign countries as beneficiaries? I think you said yes, right? And Luam said, can you make a trust beneficiary? Can you make a trust a beneficiary that I guess, can you make a trust?
Make a trust a beneficiary, yes.
Yes, okay. And then can it go to your children that when they are 18?
Yes, depending on the structure that you have listed for your trust. And that person should definitely be at the third session because I will talk about that.
I think that is all of our questions. I don't know if there's any other last minute questions.
You all have great questions.
All right, well, thank you. When is the third session? So it's every Saturday for the next 3 weeks. So next Saturday is the 18th, and this Saturday after that, if I can do my math correctly, carry the 22nd. So April 22nd would be that last session. So thank you so much, Shakisha. This was incredibly helpful and so much good information. We do have a quick survey for you guys if you don't mind filling that out and register for session 2. Make sure you are following Shakisha at the Legacy Counselor on Instagram, and we also posted her website earlier. So make sure you check that out as well. We have one more question. 401k beneficiaries is only over 18. Is that correct? Someone asked.
Yes, I would not ever name someone under 18 as a beneficiary on anything,
Okay.
including, retirement, investment beneficiaries. I would not name anyone under the age of 18.
Thank you. And then, yes, you do have to sign up for each session separately. So be sure to sign up for the part 2 and part 3. We put the links in the chat a couple of times. And so make sure you do that. And then we just shared Shakisha's website. So please check her out there as well. Thank you very much. And we will see you next week on Saturday. And this was great. Really appreciate it. You guys have a great rest of your Saturday. Thank you very much.
Thank you. And you're welcome.
Thank you. So we're just gonna give